Other countries have, whoops, if I lean on this too much, it will be an exciting event. I'll fall right off the stage. Other countries, are bound together by language or land or reverence for a king, and we, of course, are bound together by what's upstairs. The late, great historian Pauline Maier referred to the Declaration of Independence and the sight of people lining up to see it. She called it our American scripture, and of course, all those founding documents in some ways deserve that same appellation. As you know, the Second Amendment, for most of the country's history, was not one of the most discussed parts of the Constitution. We all know our Fifth Amendment rights, and we all cherish the First Amendment, but the Second Amendment was not as discussed. It was rarely raised in court. It was not as talked about until relatively recently. And as happens so frequently throughout our history, our debates over many things become constitutional debates. We go back almost by instinct to the question of where these issues stand in our constitutional framework. And with the Second Amendment, that certainly is the case. And we've seen it even just in the most painful and immediate way just in the last couple of weeks in some of the comments after the school shooting in California. As you know, within hours after the shooting, one of the parents of one of the victims said at a press conference, he said, "They talk about gun rights. What about my son Chris's right to live?" Speaking through his pain at that moment of anguish about this constitutional debate. And then a few days later, in response, in effect, Joseph Wurzelbacher, known to those of us who follow political campaigns as Joe the Plumber, said, "As harsh as this sounds," he wrote, "your dead kids don't trump my constitutional rights." Now that is an especially garish way of framing this deep and serious constitutional discussion, but it does suggest that, first off, in America, we always go back to that set of founding ideas and documents, and second, that it's time to take a deep breath and really look in a calm way at what the Second Amendment means, but what even more, what it has meant, and how that meaning, how we've interpreted that meaning, has changed over time. The book that I just published with Simon & Schuster is called The Second Amendment, A Biography, and it's called a biography because, in a sense, it's not a snapshot. What I came to recognize as I worked on it was that the way we understand the Second Amendment has changed repeatedly throughout the country's history. It is bound up endlessly and inevitably with our views of how we balance individual rights and the public good, what we think of government, how we see the role of the courts and the Supreme Court. And it is not the product, it turns out, generation by generation, it is not the product of some pristine, unchanging meaning, but rather the endless push and pull of advocacy and public debate and public discussion over time. Now, as many of you know, the Supreme Court of the United States first ruled that the Second Amendment recognizes an individual right to gun ownership in 2000 for personal protection in 2008. It was fairly recent. Even people who follow this issue often are surprised by that. Now, that case, of course, was District of Columbia versus Heller. And Justice Antonin Scalia wrote that opinion. And afterwards, he told a journalist that he was very proud of it and that it reflected, in his view, the vindication of his approach of originalism, his judicial philosophy that he's argued for over the years, that the only legitimate way to understand a constitutional provision is to ask what it meant at the time of its ratification and to the people of that generation. He said this was the vindication of it. So the first thing I did in working on this book, which I began not after Newtown, when once again we were discussing and debating the issues of gun safety and gun control. First thing I did was go back and look at that founding period, which so many of you no doubt are familiar with. And it was interesting and, to me, in many ways revelatory. There are things throughout our history and things from that founding era that I think would certainly surprise me, but I would suspect would surprise liberals and would surprise conservatives, that would surprise people on all sides of this contentious issue. The Second Amendment, of course, comes out of the period of the American Revolution and after the American Revolution and the drafting and ratification of the Constitution. And one of the things that is so striking are the ways in which that period is so different from today. The militias, which sometimes we puzzle over or skip over or view as just throat clearing in that amendment. The militias were deeply, deeply important to the worldview of Americans of that period. And I should say, I'm probably wrongly presuming that most of us probably know those 27 words of the Second Amendment, but I should spell them out for those who don't. It's just one sentence. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. And as you know, there are those stray commas in the middle that make things in that otherwise foggy sentence even more confusing than they might otherwise be. Well, one thing that was not confusing to the founding generation was the role of the militias. The militias were not like the National Guard, say, today. They're not like anything we know now. Every single adult man, and eventually every adult white man, was in the militia for their entire adult life. And they were required to own a gun by law, a military weapon, and keep it at home and bring it in. And one of the reasons the militias were to provide security, there was no police. They were to provide collective security. There was no army. They were also seen as a bulwark against tyranny, because to the colonists and then to the early Americans, the great opposite to the militias, the thing they were terrified of, was what's called a standing army. A standing army is a professional army at the command of the king that will do what the king wants, that's not made up of citizen soldiers, not made up of people bringing their weapons from home. This was a great threat in their minds, and of course it had been a great threat in their lives. The British Army had just sailed away shortly before the Constitution was written. So the militias, these forces of citizen soldiers, were deeply important throughout the Revolution, especially at the beginning. If you think about Lexington and Concord, it was the Minutemen were the militias of Massachusetts, and they were woven tightly into the fabric of colonial government. John Galvin, the NATO commander, has written about the Battle of Lexington and the Battle of Concord, and showing about the military tactics used by the governments of the towns around Boston. The militias, though, didn't really work out so well throughout the whole war. They found they needed an army. They wound up playing not such a big role in the actual war, though they retained their place in the minds of Americans. Then after the Revolution, as you know, the country developed quite a bit of chaos. The Articles of Confederation weren't working. There was armed violence and threats of anarchy, such as Shays' Rebellion. And many people who'd been very active in the Revolution, especially young men who served in the Continental Army, went off and went behind closed doors and wrote what we now know as the Constitution through the Constitutional Convention. They were thrusting unmistakably toward a stronger national government. When you look at the Constitutional Convention notes that James Madison took, they discussed quite a bit this question of the militias, quite a bit the fear that they had that there would be a standing army and what they needed to do to make sure that the militias were strong, but also recognizing that they were going to, in effect, nationalize the militias. When you look at the Constitution itself, there's a long section that we kind of skip over that talks in great detail about the militias and how they'll be governed and how the president can command them and who's going to pick the officers, who's going to make sure they're armed and all that sort of thing. That stuff was very important to them then. Well, as you know, they released the Constitution. Nobody knew what was going to be in it. There was a newspaper, the Philadelphia Packet, that reported, we hear that the Constitutional Convention, they didn't call it the Constitutional Convention, we hear that the convention proposed to adjourn next week. The year 1776 is celebrated for a revolution in favor of liberty. The year 1787, it is expected, will be celebrated with equal joy for a revolution in favor of government. Well, that's not exactly how it turned out. The Constitution was released, had a lot of momentum behind it, but as you know, there was a massive, fierce, grand debate over ratification, over what the shape and role of this new government should be. And there were tremendous fears expressed. And most of the opposition, by what were, in a early example of very deft spin, the pro-Constitution supporters, who were the Federalists, dubbed the opponents the Anti-Federalists, and they objected to that enormously, but the name stuck. The Anti-Federalists were worried about many things. They were worried about taxation. They were worried about representation. They were worried about the role of the federal courts. But one of the things they were very worried about was the standing army, and the idea that there could be an army and that it could crush those 13 state militias, which they saw as part of their freedom. And the Constitution was rolled through the states. There was ratification fights. As you know, the first one was in Pennsylvania, and some of the opponents raised objections, and they were not even allowed to bring them up on the floor of the ratification convention. They wound up publishing them as a pamphlet, which was published throughout the states. It wound up rolling forward and getting ratified, but as some of the bigger states loomed into play, Massachusetts and Virginia and New York, the anti-ratification forces were strong, and there became, in effect, a formula for getting the Constitution ratified, which was at the very last minute, some major figures like John Hancock would announce that they were going to support the Constitution after all, but that they thought there ought to be amendments. And so through this process, dozens of amendments, contradictory all over the map on all different kinds of issues, some of them dealing with the militia, some of them, many fewer, dealing more explicitly with right to arms, came out of the process. It was a big jumble. The Constitution got ratified. It's upstairs. We know it's there. But that would not necessarily have produced a Bill of Rights. That would not necessarily have produced any of the 10 amendments, let alone the Second Amendment, without the quirks, the vagaries of one congressional district. James Madison, we call him, and I think he thought of himself as the father of the Constitution. Many of the people who call him that would be shocked to learn what his actual views were. I mean, for example, he thought it was really important that Congress be able to veto all the laws of all the states. He was much more at that point of an ardent big government nationalist than a lot of his fans would want to admit right now. Madison did not think there ought to be a Bill of Rights. He had helped write the Constitution. He wrote the Federalist Papers with others, arguing it didn't need to be changed. He was like a campaign manager for the ratification campaign in many states. And he thought, for a number of reasons, that amendments were a bad idea. But he wanted to be in the Congress. James Madison, as we might say now, was against the Bill of Rights before he was for it. He wanted to be in the Congress. His political enemies in Virginia kept him from getting a Senate seat, which was a luxurious 6 years, which is what he thought he should have. So he said, well, I'm going to have to run for the House of Representatives. He ran in the very first election. He had a gerrymandered district. 20 years before Elbridge Gerry signed his name to the district that gives gerrymandering its name, Patrick Henry did it to James Madison. It was a district where the only part of the district that was pro-Constitution was his house. They ran against him. He was shy and bookish and slight and sickly, or hypochondriacal, depending on how you look at it. They ran against him, a charismatic war hero who had a British musket ball in his lung, James Monroe, who the farmers of that district would definitely rather drink a cider with Monroe than they would with Madison. And the charge against Madison was, you support the Constitution, and you don't want it changed. And that was going to be enough to cost him the election. And the swing vote in the district were the Baptists. Now, we think of Southern Baptists more recently as a fairly reliable conservative voting bloc. Then they were the They were the religious dissidents, free-thinking religious dissidents. They were oppressed by the Episcopalians in Virginia. And they said to Madison, we'll vote for you if you change your position and come out for a religious freedom amendment. So James Madison, in that race, executed the first great flip-flop in American political history. He said, he did this through one of these letters that got leaked that deliberately. He said, I opposed all previous alterations as calculated to throw the states into dangerous contentions. He said, that was then. He said, circumstances are now changed. This is a line that has been used many thousands of times by politicians ever since then. He vowed to pass amendments. He won by 339 votes. And so he now had to go to Congress and try to pass amendments. And when he got there, people were not interested. At that point, the Federalists had won the election. They regarded this agitation about the Constitution as a lot of noise. And a lot of it was noise. It was fear of tyranny, fear that George Washington was trying to set himself up as a king, fear of all this stuff. It was contradictory. There was obviously a lot of deep philosophical underpinning to some of it, but a lot of it was just the kind of noise that politicians feel, at least a lot of the time, that they're dealing with all the time. And they were not interested in responding to it. Madison felt it was necessary. He thought that there would be a call for another convention if they didn't do it. So he had to push and push and push to get them to take seriously the idea of amendments. After a bunch of false starts, on June 8th, 1789, which is next Sunday, it's the anniversary, James Madison stood up on the floor of the House of Representatives and introduced 17 amendments to the Constitution. And so one of the things I'll mention is that there were 17 amendments, and when we think of the Bill of Rights as like a decalogue, or a poem, or a song, or something where you have 10 items, Madison proposed 17. What is now the Second Amendment was number 5. The first one had to do with the size of congressional districts. The second one had to deal with congressional pay, and so on. And he read them, and there was, you can tell even now we don't have C-SPAN, but there was a lot of eye-rolling in the Congress. One of his colleagues wrote a letter going through Madison's amendments, and he said, oh, and I forgot, the right to bear arms. And then he had a Latin phrase, this congressman wrote, and it means, stifle your laughter, friends. And Madison's version was proposed. It went into a committee. The committee rewrote it a bit and moved things around, and it then it eventually passed. And it went to the Senate. The Senate, at that time, only the House of Representatives was open to the public. The Senate was secret, so we don't actually know what the nature of the debate was in the Senate. There are rumors printed in various letters, but not much more than that. There's very little to know what they actually thought they were doing in writing the Second Amendment. But we do know this. As I said at the beginning, the focus emphatically in the minds of the founders was on the question of the militia and how to preserve it as a bulwark against tyranny, how to give the states the ability to ward off a tyrannical central government. And again, the militia was not like anything we have now. It was, in fact, private citizens, citizen soldiers, required by law to have a gun. All of Madison's notes from the Constitutional Convention, in all of the official records that we have from the state ratification conventions, with a few scattered exceptions, and the entire records of the debate in the House of Representatives, there's not a word about an individual right to gun ownership for hunting or self-protection or any of the things we talk about right now in the debate over gun rights in America. It's all about the militias and private gun ownership as part of the militias. So I'm asked, as you can imagine, doing a book like this, I'm asked all the time, so what is it? Is it an individual right or is it the militias? And the answer is, it's both, and it's neither. It was an individual right to fulfill the duty to serve in a militia. Our question to the founders would make no sense, just as in some ways their answers make no sense. And so one of the things that I drew from this was that we are not going to find the answer to the questions about gun ownership, gun rights, gun policy by going back in a time machine and tapping James Madison on the shoulder and asking him. It was such a completely different approach that they were taking that we can draw some principles, but the underlying principles, but they were very focused plainly on the militias. Now, it's important to point out, folks who passionately believe that there is, in fact, within the Second Amendment, an individual right to gun ownership that is articulated. There were plenty of guns, and in fact, there was the view that you had a right to self-defense that Blackstone, the English jurist, describes, and that came down to the colonists from Britain, from England. There was a different version of right to bear arms in the English Bill of Rights that was not necessarily applicable, but plainly they thought there were a lot of guns. People thought they had a right to have the guns. There were also plenty of gun laws, and it was understood at the time, such as you couldn't store gunpowder within the city of Boston or other places. You couldn't have guns fired within a city. There were all kinds of restrictions. But they didn't think they were putting those in from what I can tell, they didn't think they were putting those in the Constitution through the Second Amendment. So it's obviously not the case that there were not guns, and it's obviously not the case that they didn't think that people had a right to protect themselves. But they just didn't think that that's what they were doing, at least based on what they said in the Second Amendment. Then something interesting happened. 2 months after the Second Amendment got ratified, and again, when it went out to the states, there's almost no record of any kind of what people were said about it. There's no newspaper articles. It's quite an astonishing thing. Pretty quickly, the federal government passed a law requiring everyone to buy their gun, and nothing happened. The militia system began to crumble. People stopped showing up. People stopped buying their guns. The country began to change. We became a much more individualistic country, more materialistic, less focused on things like serving in your local militia. We moved west. There were plenty of guns, of course. I always say, just ask Alexander Hamilton. They had guns. But there were gun laws as well. Our view of the Second Amendment, or our view of gun ownership, evolved more and more toward an individual sense of it, but not necessarily with a view that the Second Amendment was what people would appeal to. You had, throughout, based on people's views of government, you had occasional recourse to this question. In the Wild West, there were plenty of guns, obviously, but there were gun restrictions, and there's a wonderful photograph of Dodge City from 1888, the archetypal frontier town. It looks like a movie set. It's a dusty main street. There's saloon doors and hitching posts. It really looks like Gary Cooper should walk down the street. And it says, "Welcome to Dodge City, firearms prohibited." There's a sign right in the middle of the street. So even there were guns and there were restrictions on guns. The issue of guns arose during the Civil War as well, and the 14th Amendment. After the war was over, you had hundreds of thousands of freedmen, who went back to their homes in the South. And many of them had served in the Union Army. And the southern states quickly passed laws disarming only African Americans and not whites. And immediately vigilantism began, and the Ku Klux Klan and other terrorists assaulted the black communities in the South. And one of the purposes of the 14th Amendment was to make sure that those African Americans could get guns, could have access to guns. And the question is, did they mean they had to have them access on the same terms as whites? The same military governments that enforced this also had very strict laws, for example, banning carrying of weapons. But even then, there was an ambiguity of what we meant. So we grew as a country. We had guns and we had gun laws. And for 2 centuries almost, we evolved. It was fought out at the ballot box. It was fought out in legislatures. And it was not fought out in the Supreme Court because this strong consensus was that the Second Amendment was about the militias. And when I mentioned that the Supreme Court first ruled in 2008, it had ruled several times previously, most directly in 1939, that the Second Amendment was not about individual rights to own or not own guns outside militia service. In 1991, Warren Burger, the retired Chief Justice of the United States, a strong conservative appointed by Richard Nixon, articulated the conventional wisdom. He said the idea that the Second Amendment recognized an individual unlimited right to gun ownership was a fraud on the American public. Those were his words. So what changed? What happened? Well, what changed, what happened, is what happens all throughout American history. People who cared passionately waged a long-term campaign to change how we saw the Constitution, to change what the Supreme Court thought, to change the way that provision, that amendment, was read. The National Rifle Association played a very significant role. And again, it is, whether you agree or disagree with the substance of it, what they did is a classic story of constitutional change in America. Now, the NRA, it bills itself on its website as the oldest civil rights organization in the United States. It started, not quite with that frame, it was started by former Union officers who were concerned about poor marksmanship by their troops. General Burnside, the one with the sideburns, was the first president. They trained people in shooting. They trained people in safety. It became known over time as an organization that spoke for sportsmen, especially for hunters. It testified for gun control laws. It was asked at a congressional hearing on the first federal gun law, do you see any constitutional problem with this? And they said they couldn't think of any provision of the Constitution that would be relevant. Something changed. Well, what changed? In 1977, there was a retreat anticipated even further by the NRA from politics. And it had its annual meeting in Cincinnati, and it's known as the Revolt at Cincinnati. And activists showed up at the meeting and ousted the previous leadership and backed new leadership, new, much more doctrinal, much more intensely focused on the Second Amendment, much more devoted to making a constitutional crusade out of this issue. And as I talk about in the book, this was not an unusual thing. We think about the 1960s as this period of huge change. Well, it turns out that the backlash to the 1960s, which happened in the 1970s, has had more of an impact in some respects on all of our living experiences than the 60s did. It was not only at the NRA that there was a big change. In the evangelical churches and the farm organizations and the business lobbies all moved sharply to the right, all moved much more toward an alliance with one of the political parties, the Republican Party. And the NRA changed its focus emphatically toward the Second Amendment. And it waged a classic campaign. And my organization, the Brennan Center, we work on a lot of different issues on voting rights and criminal justice and campaign finance, and we realized that the model the NRA used is a model that had been used by others throughout time. They started with scholarship to go and try and prove that, in fact, what the founders meant was an individual right. They moved public opinion so that eventually, and in a change, the overwhelming mainstream public opinion was that the Second Amendment was, in fact, talking about an individual right. They moved the organs of government so that the politicians were elected and that the Justice Department changed its position. And then, and only then, did gun rights advocates go to court. It wasn't even the NRA. It was the Cato Institute and others who thought the NRA was too timid. But by the time that case, the Heller case, by the time that got to the Supreme Court, it fell like a ripe apple from the tree. Nobody was surprised. It was reflecting a massive change in public opinion, legal opinion, and this hugely successful 3-decade campaign. And when you go to the NRA's headquarters, even now, you go into the lobby out in Virginia, and there on the wall in its pride of place is the Second Amendment, except you have to look closely. It's edited. It just says the right of the people to keep and bear arms shall not be infringed. The first part, which was so important to the framers, is just actually edited out. It only has 2 dots. It doesn't even have 3 dots. You have to look closely. That, in effect, Justice Scalia, in his opinion, 64 pages, 2 of the pages were about the militias. And the rest were about the second half of that provision. Well, what next? What does this mean now? I'll be brief. It was really interesting. Despite the finery, the originalist finery in which that opinion was clothed, it actually said something a little bit less dramatic. It said, yes, there's an individual right to gun ownership. It struck down the District of Columbia's law dealing with handgun ownership in the home. Very different from marching around the village green in New England. But it said that protection of hearth and home with commonly used weapons, that was at the heart of the Second Amendment. So yes, there's an individual right, but as with any other right, that can be limited. It even spelled out a few of the limits, but didn't really say what the extent of the right was and didn't really say what the limits were. That's now something all of us are fighting over and figuring out. And what's happened that's interesting is this. There have been dozens and dozens of cases. The Supreme Court did one more big ruling on this, and 2 years later, in the McDonald case, it applied the Second Amendment to the states through the 14th Amendment. There have been dozens of cases since then. And in almost all of them, the judges have upheld existing gun laws. Said, yes, the Heller case and McDonald, those are our body of law. Yes, there's an individual right, but there's also a society's right to protect itself. There's also a strong governmental interest in strong criminal laws, and these laws meet that balance. I said almost all the courts. There are some cases that could pose a split in that. In fact, the one that many of you maybe know about out in California called the Peruta case, which is in the Ninth Circuit of the federal courts, which is the most liberal circuit. The Supreme Court usually loves to take cases from the Ninth Circuit so they can overrule them. An appeals court there actually struck down San Diego's law and in effect California's law on carrying guns. The issue of what kind of rules govern guns carried outside the home is the hot issue now. We see a lot of agitation on that. We see the same kind of attempt to move public opinion on that legal issue that we saw before. And the open carry movement in Texas that's gotten a lot of attention in the last few weeks, or the law in Georgia that makes it legal, and that's a law, not a constitutional provision, to carry guns into many more places. So the Supreme Court will speak on this again. I think it's very likely that they will speak on it again, although they have not chosen to yet. So what's going to happen? Well, it's going to be a big debate. It's a debate that's going to continue. It's not going to end. It shouldn't end. It goes, as I suggested, to the heart of our sense of ourselves, our sense of our rights, our sense of our government and our country. One thing that I do hope that I would interject as an editorial matter is that this is an issue where looking at the facts of what goes on with guns lead to some surprising conclusions. We have many, many, many guns in this country. Nobody's going to, even if someone wanted to, nobody's taking them away. There are almost 300 million guns in the United States. That's, of course, many more than other countries. And the number of guns is growing, but the number of gun owners is shrinking. Fewer gun owners have more guns, and the number of gun crimes is going down too. And there are reasons to think that in some ways this problem can work itself out through things like technology and legal matters that aren't about core gun control issues alone. There's a statistic that I saw last week. The United States has, this year, more people killed by guns, 33,000, than by cars. Now, at one level, to me, that's a horrifying statistic. Another, it gives hope. It's partly because a lot more people used to be killed by cars. What happened? They didn't ban cars. They didn't seize cars. They changed the drinking age. They put in seatbelts, airbags. They changed the designs of cars. They found technological ways to make cars safer. One can imagine similar improvements to make guns less dangerous to people who shouldn't have them. But Second Amendment fundamentalism, an endless recourse to rights without responsibilities, a premature reliance on the courts is not going to make that solution any easier. Ultimately, I think this is something that ought to be fought in the ballot box, in the court of public opinion, in the legislature and less effectively and less wisely in the constitutional courts. I'll close with something Abraham Lincoln said that I think is always a very important reminder from another constitutional issue, which had to do, of course, with slavery. He said, with public opinion, with public sentiment is everything. With public sentiment, nothing can fail. Without it, nothing can succeed. Consequently, he who molds public sentiment goes deeper than he who enacts statutes or pronounces decisions. He makes statutes and decisions possible or impossible to be executed. It was true for Lincoln. It was true in the past for the Second Amendment, and it's going to be true going forward. So thank you for your attentiveness, and I'm eager to have a conversation and answer any questions. So we have microphones, from what I gather.
Hi, I'd like a little more information about the 1977 takeover at the NRA. My perception is that those were essentially corporate interests that did that to sell more guns. Am I right or wrong about that?
I'm not a first-hand expert on that, but that is not my sense of it. My sense is that that there is a vast number of Americans who passionately care about this issue and see it as a matter of their fundamental rights, and that they were the folks who showed up in droves at that meeting in Cincinnati. They were actually other organizations, the Citizens, I believe the Citizens Committee to Keep and Bear Arms, and one or two others that were more Second Amendment focused than the NRA, and a lot of the folks came in from there. According to the journalism I've read, support for the NRA from gun companies really is a much more recent phenomenon, actually within the last 10 or 15 years, in part because NRA members boycotted gun companies that reached agreements with President Bill Clinton, for example, on public safety, on shipping trigger locks with guns. So I think that it's much more of a deeply felt and widely felt belief than that.
Thank you.
In the Heller opinion, Justice Scalia, who is not only an originalist but also a textualist, said that the syntax of the Second Amendment, which strikes us as odd, in fact was not odd at the time and supported his construction focusing on the individual right. What do you think of that?
Good question. Well, so that's one of the things that so first off, to clarify what the questioner has asked, Justice Scalia especially focuses in his mind on the words, and not only the meaning, even the meaning to people at the time. He relies frequently, for example, as he did in that decision, on dictionaries, and looking at 19th century, 18th century dictionaries to see what the individual words meant. There are a lot of scholars who think that that's wrong, who think that the construction was unusual, and in fact it's unusual if you just look at the other 9 amendments. It's the only one, for example, with a prefatory clause. It's the only one we have these kind of debates over what it means. Some people have pointed out that because it was both talking about the militias, which was a kind of a more Republican, as they call it, an earlier concept of how to protect your freedom. And a lot of the other amendments are more drawing on the individualist views of somebody like John Locke. They actually read more modern to us than that does. It's also the case that one of the things that I criticize Justice Scalia for doing in the opinion is he looked at the words with the dictionaries, and I liken it to sort of a really ambitious Scrabble player, going to the dictionary to prove that triple score word really exists. He looks at the words individually and out of context and out of order. That's one. It's important to know what the words meant, but there was also in the heart of that amendment a phrase, bear arms. And that had a fairly distinct meaning to the people of the time. It was a military meaning. And this wonderful institution, the National Archives and the Library of Congress and other institutions that have put so much online, enable us to see how much bear arms was a military concept to the people of that generation. If you look at the papers of I call them the six most famous founders: Washington, Adams, and Jefferson, Hamilton, Madison, and Franklin. It's called The Founders Online, and it was put online last year. And you can search for the word bear arms or bearing arms, the phrase, in all their papers. And other than the ones where they say, hey, did you see this? We have a Second Amendment. So cutting those out of something like 150, all 150 referred to bear arms or bearing arms in a military context. Not, I have a gun, I'm carrying it around. So I'm critical, and others have been critical too, of Scalia's reasoning there. And as you may know, the reaction to the Heller opinion was really interesting. It didn't fall predictably. The politicians of left and right all cheered. McCain and Obama were running, and it was the last big opinion before the 2008 election. They all said, yes, great, off the table. We don't have to worry about this now. And said that, yes, the individual right is there, and now you don't have to worry, we're going to take your guns away. Liberal scholars sort of shrugged and said, well, what do you expect? This was not originalism, this was living constitutionalism. This was a change. Conservative judges and conservative scholars have been witheringly critical because they argued that Heller, in the way it twisted history, did the same kinds of things that they had been criticizing liberal judges for doing before. Judge Harvey Wilkinson from Virginia, a very conservative judge who President George W. Bush interviewed to appoint to the Supreme Court, he has written about it very strongly and said it's as bad as Roe versus Wade, which for him means that it was made up. And Judge Richard Posner of the Seventh Circuit on different grounds was equally critical. So there's a lot of controversy, as you can guess, about those very issues. Yes?
Well, first, thank you for that very incisive and insightful discussion, historical discussion. I say that, of course, because I agree with it, which makes it brilliant. But the point that wasn't mentioned, that's always out there, if you study any kind of American issue, kind of the thing is, especially when politics, follow the money. And a lot of people would probably come up and argue it's a money issue. So what role, if any, do you think that money played in any change? And of course, some validation of that is there, when you really look at the number of NRA members, there aren't a whole lot for the power. It is truly one of the most powerful organizations we've ever seen in history. So could you comment on kind of both of that, the role of money and especially as it plays into the NRA?
Well, I would preface the answer by saying, as I said to the other gentleman, that I think that the power that the NRA has is more their passion than the money. And it's a classic political scientist's conundrum that passion, and in this instance voting as a single issue voter, can, even if you're a smaller group, can trump the more widely held and less strongly felt views perhaps of a majority. And a good example of that, of course, was last year in the wake of Newtown when the Senate was debating the bipartisan bill to strengthen background checks and extend them especially to gun shows, Manchin Toomey, and had support of 90% of the public and was blocked by a filibuster. Although I would say that is more about the filibuster rules of the Senate than anything else, because a majority of the Senate voted for it too. The passion, the willingness to vote on a single issue is the key for the NRA, from what I can see. You have NRA, for example, scoring judicial nominations now of Elena Kagan and Justice Sotomayor, so that Justice Kagan and Justice Sotomayor, so that they received the fewest votes of any justices in years, and it was because the NRA scored them. And if you want to get a perfect NRA rating, you had to vote that way. The question about money, again, I don't think that the NRA's power comes from spending money in elections. Having said that, it has been a consistent opponent of laws to regulate the spending of money in elections, and has been part of the coalition, both of business and of social groups, pushing in a different constitutional campaign that does not have the same broad support that the gun rights do, to strip away and deregulate campaign finance in the United States. So, but I think that the money obviously plays a role. The NRA claims 4 million members. AARP has 30 million members. It's not actually that big. It's more the passion. Yes.
Thank you.
taking the amendment as a whole, especially what you've said about bear arms as in the context of that time of military, I've always been curious why the focus has been on small arms only as opposed to larger arms. Obviously, there's storage and costs involved of storing a tank or whatever, but why is the focus only on small arms and not the right to have a tank or a ship or whatever to protect against tyrants in government?
Well, it's a good question. No, but in a way, one could argue that the true meaning of the Second Amendment would be you could have a bazooka but not a handgun, or that the right to a bazooka is protected but not a handgun. It hasn't played out that way, although in a sense the question about assault weapons and restrictions on the size of magazines, in other words, the fastest growing weapon in the United States in terms of sales is the AR-15, which is a military weapon, and it's not being used in the military, but it is a military weapon. So that is one of the kinds of issues that's going to have to get debated. Although the Heller decision said that weapons need to be kind of standard weapons for self-protection, and even at least one of the attorneys who brought the Heller case said that he thinks plainly that assault weapon ban could clearly be constitutional. But it's a good question. I mean, what it really goes back to is they were not debating about the weapons. They were debating about the military system and the checks and balances on federal power that use of military weapons was embedded in. Some people say, well, so doesn't this mean everybody has an individual right to weapons, military or otherwise, to stand up against tyranny? And if you think about Cliven Bundy, the rancher out a couple months ago who had a standoff with federal forces, Bundy said he was just following in the footsteps of the founders. But if you go back again and look at it, and this is where it's sometimes hard to find one voice, one original meaning, one original intent. Of course, to the founders who actually wrote the Constitution and ratified it, they were horrified by Shays' Rebellion. They were horrified by the idea of unregulated, of non-governmental armed people taking arms against the government. On the other hand, there were probably plenty of Americans at the time who thought they were just embodying the spirit of 1776 when they did just that. We know that George Washington led militia to go crush the Whiskey Rebellion right at the same time, to make it clear, no, we're not talking about anybody with a gun claiming they're the militia. We're talking about the well-regulated militia. Yes?
Well, you alluded to the fact that when the 14th Amendment was passed, one of the things that came up, and I think Clarence Thomas said this in a concurring opinion, that it was the main purposes was to keep blacks from being disarmed in the South by, in fact, as I understand it, Southern militia who were just disarming only blacks but not whites, and the blacks couldn't defend themselves against the Klan, even against the militia. And so it really, in that case, at least it appeared to be a right to defend yourself, and in fact, and sometimes against the Southern militias. So.
Yeah, and it's an interesting, so that, just as I suggested that the world of colonial militias is so different from now that we cannot understand how best to interpret the Constitution simply by asking what they meant back then. I guess I would argue to a certain degree that there's ambiguity in what the 14th Amendment meant, and also that it's enough of a different time that it's hard to draw precise lines. It was a kind of a time of low-grade guerrilla racial war in the South. And you're right that the vigilantes included not only the Klan, but the Democratic Party militias. And the Southern blacks who were sought to be protected not only were going to protect their homes, but also to form their own militias, or to form Republican militias and state militias. And in fact, one of the cases that, one of the shameful cases where the Supreme Court helped destroy Reconstruction in the South and usher in the era of Jim Crow and usher in another century of oppression in the South had to do with the Second Amendment. It was called Cruikshank, and it involved, there was a disputed election in Louisiana. Some said the Republican candidate won, some said the Democratic candidate won, white militias, Democratic Party militias, attacked black militia and basically families and massacred them in Colfax, Louisiana. And when it went up to the Supreme Court said no. First of all, the clause that Clarence Thomas believes affects this most directly is the Privileges and Immunities Clause of the 14th Amendment. The Cruikshank case basically said that has no meaning. And we're not applying any of this stuff to the states anyway. This is only applied to the federal government, including specifically the Second Amendment. So, the 14th Amendment, of course, is a majestic statement of civic and legal equality. It is not, I would suggest it's not confusing like the Second Amendment, but it sure is vague. And it's for up to all of us always to interpret what it means. The challenge with it as it relates to this is, did they mean that there was some kind of, as Clarence Thomas would argue, a right to gun ownership that cannot be taken away under the 14th Amendment? Or did it mean that you can't take away guns from blacks but not from whites? And so, that too is something we're always debating about. So I think we are close to done. I want to thank you all again for being here. Thank you for being part of this great debate. I am told that we have, for anybody who is interested, we have books for sale and for signature up in the bookstore. And thanks so much for your attention.